Displays are said to be almost always ambiguous. It's a presumption that displays are invitation to treat unless special circumstances are present. Boots Cash Chemists had just instituted a new method for its customer to buy certain medicines. The company would let shoppers pick drugs off the shelves and then pay for them at the till. Before then, all medicines were stored behind a counter and an assistant had to get what was requested. The Pharmaceutical Society of Great Britain objected and argued that under the Pharmacy and Poisons Act 1933, that was an unlawful practice. Under Section 18, subsection 1, a pharmacist needed to supervise at the point where the sale is effected, when the product was one listed on the 1933 Act Schedule of Poisons. The society argued that the displays of the goods were an offer, and when a shopper selected and put the drugs into their shopping basket, that was an acceptance. Therefore, because no pharmacist had supervised the transaction at this point, Boots was in breach of the Act. Boots argued that the sale was effected only at the till. Both the Queen's Bench Division of the High Court and the Court of Appeal sided with Boots. They held that the display of goods was not an offer. Rather, by placing the goods into the basket, it was the customer that made the offer to buy the goods. This offer could be either accepted or rejected by the pharmacist at the cash desk. The moment of the completion of contract was at the cash desk, in the presence of a supervising pharmacist. Therefore, there was no violation of the Act. Let's look at another important case here. The case involves display of a flick knife in the shop window when it was criminal offense to offer flick knives for sale. In Fisher v. Bell, the defendant displayed a flick knife in the window of his shop next to a ticket bearing words, "Ejector Knife 4S." Under the Restriction of Offensive Weapons Act 1959, Section 1, subsection 1, it was illegal to manufacture, sell, hire, or offer for sale or hire, or lend to any other person, amongst other things, any knife which has a blade which opens automatically by hand pressure applied to a button, spring or other device in or attached to the handle of the knife. On 14 December 1959, the claimant, a chief inspector of police force, brought forward the information against the defendant, alleging the defendant has contravened Section 1, subsection 1 by offering the flick knife for sale. This loophole was closed by Restriction of Offensive Weapons Act 1961, ban on flick knives, which inserted after the words offer for sale or hire the words or exposes or has in possession for the purpose of sale or hire. At first instance, the prosecutor submitted that the defendant has displayed the knife and ticket in the window with the object of attracting a buyer, and that this constituted an offer of sale sufficient to create a criminal liability under Section 1, subsection 1 of the Act. The defendant submitted that this was not sufficient to constitute an offer. The judges at first instance found that displaying the knife was merely an invitation to treat and not an offer, and thus no liability arose. The prosecutor appealed to the judge's decision. Court of Appeal upheld that, although the display of a knife in a window might at first appear to lay people to be an offer inviting people to buy it, and that it would be nonsense to say that it was not offering it for sale. Whether an item is offered for the purpose of the statute in question must be construed in the context of general law of the country. He stated that the general law of the country clearly established that merely displaying an item constituted an invitation to treat. He also read the statute on an exclusive construction, noting that other legislation prohibiting the sale of weapons referred to offering or exposing for sale. The lack of the words exposing for sale in the Restriction of Offensive Weapons Act 1959 suggested that only a true offer would be prohibited by the Act. The court dismissed the appeal. Looking at these two cases, it is safe to say that displays are presumed to be invitations to treat.